Okay, it looks like Mr. Brown and Ms. Klein are both in the virtual courtroom. Mr. Brown, we understand you had a little bit of a problem getting to the location to argue, so we're glad you made it, and we are ready with the argument. And just as a reminder, because you weren't here at the beginning, 20 minutes per side. If you wish to reserve up to 5 minutes for rebuttal, just let me know, and I'll let you know when you get to that point in your argument.
Yes, Your Honor. First of all, good morning, Your Honors. I'm Ms. Klein, and I do apologize for holding anyone up, especially you, Ms. Klein, since you were waiting just on me. It was a little harrowing experience, but I would ask to reserve, if it please the court, 5 minutes at the end of my argument. And if it please the court, I'll begin now. I have the honor of representing the appellant, Mr. Tanner, in this case. Unless the court has a preference, I will go ahead and address our issues in order, and of course, expecting the court to jump in as the court has questions. Mr. Tanner raises 5 issues on appeal. In issue number 1 is the issue of his statement. The trial was a slightly unusual one in that, well, every trial is unusual in its own way, but in that the victim never testified live. She actually testified at sentencing in Mr. Tanner's behalf. The test of the 911.
Actually, Mr. Brown, can I isolate on that issue? I know I'm truncating what you're trying to do, but
yes, sir.
In closing argument, the prosecutor either stated overtly or alluded to the fact that she didn't testify because she was afraid, right? Am I correct in that?
Yes, she did.
Okay. Well, the reason why I asked that, because she again then showed up at sentencing and spoke in favor of the defendant. Is that also accurate?
That is accurate.
Okay. So what was the basis, what was the evidentiary basis in the closing argument for the prosecutor's comment? Was that just come out of the blue, or was there any testimony to support that, or is that just a gratuitous comment? I mean, and I realize I'm dwelling on something that isn't necessarily a big issue in this case, but I was really bothered by it. So don't, get to it quickly and get out and get to the stuff you want to get to.
Well, yes, Your Honor, and I'm not trying to butter up the panel by saying I absolutely agree with you, but I do. It's something that the appellant gave consideration as to seriously adding that as a 6th issue. However, it seemed that the comment bordered on misconduct, but it also bordered on fair comment on the evidence. If the prosecutor was unaware, and there's no record evidence she was aware that before sentencing that the victim was favorable to the appellant, only that the victim either was unavailable to testify or didn't want to. So the prosecutor's comment, I think that the government, the state could argue was one that is fairly susceptible to being interpreted as her saying, you may believe that she didn't testify because she's scared. However, there was no record evidence that she wasn't testifying because she was scared either.
Well, I guess the other thing that bothers me is that is her witness. Yes. I was a prosecutor back when dinosaurs roamed the earth, and I know how you talk to your witnesses. I get all that. So anyway, I don't want to dwell on it anymore. I was just really bothered by it. It sounds like there was no real evidentiary basis for it. It's a fair comment, maybe under the facts of the case, but I'm really bothered because I know she had conversations with that witness, and that witness told her whatever she told her, but we'll never know what that was. So enough of that. Go ahead, move on.
And again, as one last remark on that, I did comb through the record carefully to determine if there was a record that she'd actually spoken to her, or whether or not it could be argued that she just couldn't, that the witness was unresponsive to her. So she was commenting saying, I don't know the reason for that, but I will move on, but thank you for raising that, Judge. So in issue 1, and the most glaring issue that pops out immediately in this case is the statement that Mr. Tanner gave after several hours in the woods, in the cold and the wet. And I will say officers did put him in a warm vehicle, and I'm not trying to say they physically mistreated him or in any way intimidated him, but officers then Mirandized him. And there's 2 issues which the trial court addressed, both with a perfunctory order. Not only does the court decide these mixed issues of law and fact de novo, but that order does not really make findings of fact other to simply say he waived his rights and then didn't unequivocally unwaive them. So we contest both those issues in issue 1 of the appeal. First of all, that his mere silence and beginning to answer questions, especially the way in which he begins to answer them, is not a waiver.
Mr. Brown, can I interrupt you again? I'm sorry, but
yes,
this case has lots of troubling things for me.
Yes,
so at the end of reading your client Miranda, no one ever said the typical language that I remember is having these rights in mind. Do you wish to speak to us now? No one ever asked that question. Right?
Correct.
So
And in
what's the state of the law on that? Do they have to ask that question?
Well, I did a lot of research. I even looked outside of our state, and this is interesting in that I had always assumed that they did, because for the first 10 or 15 of my 20 plus years of practice on the criminal side as a defense attorney, it was always asked, and I almost considered it to be an unofficial part of the Miranda warnings.
Me too.
In recent years, I have noticed, and this isn't record evidence, it's just my comment, but I would say, and other practitioners would agree, law enforcement has consciously removed that and simply finished the warnings and said, now let me put you under oath. So our argument is that that minimizes the warnings and their effectiveness. Now, there's a case that addresses this from the Florida Supreme Court in 2013, cited in the brief. It's Kalisz. I don't know if I'm pronouncing that right. Kalizz v. State, 124 Southern 3rd, 185. In that case, our Supreme Court cited with approval to the U.S. Supremes, which is always a good idea, in Berquist versus Thompson, which is cited in our brief, Tompkins, and specifically talking about the original Miranda decision and its import, saying some language in Miranda could be read to indicate that waivers are difficult to establish absent an explicit written waiver or a formal express oral statement. Miranda said, quote, a valid waiver will not be presumed simply from the silence of the accused after warnings are given, or simply from the fact, as in this case, that a confession was in fact eventually obtained. So it seems our Florida Supreme Court is saying we're going to stop short of a bright line that you have to ask the question.
Hold on just a second, counsel, because when you read on in that the very next line, this is again the Florida Supreme Court going back to what the U.S. Supreme Court said. The next lines are, however, the Supreme Court also concluded that the course of decision since Miranda demonstrated that waivers can be established absent formal or express statements of waiver. The court, again referring to the U.S. Supreme Court, reiterated that the main purpose of Miranda is to ensure that the accused is advised of and understands his rights. That's the purpose. Thus, the court concluded that the prosecution does not need to show that a waiver of Miranda rights was expressed. An implicit waiver of the right to remain silent is sufficient to admit a suspect statement into evidence. You can read that portion of Kalisz, and I'm not sure how you pronounce that either. I'm going to go with Kalisz. You can read that portion to arguably support the state's position here, right?
You could in a vacuum, respectfully, and I agree that, of course, that's what the case says. And the appellant's position is not that a written or express oral waiver is required. And that's, I agree with Your Honor, that's not what Kalisz says. It strongly suggests it's a good idea.
That's the argument that I understand, and I, sitting off the fly, I don't necessarily disagree with that assessment, but it's one thing to say, hey, this is best practices, probably ought to do it, and another thing to say, you violated Miranda. Now everything that comes afterwards is no good.
Agreed, and that is not our argument. In fact, really, these are two issues that are conflated, because issue one of issue one is whether or not there was a waiver, but it's conflated really with issue two, with whether or not he revoked it, because when he begins speaking with them, he makes these multiple comments about not wanting to tell his side, not wanting to talk to them. I have nothing to say. So not only are those,
I think that's the stronger point actually between the two.
Well, we're arguing that not only do those show a unequivocal revocation if there was a waiver, we're showing that there never was a waiver, because he's still continuing in the beginning after they read him, after they swear him in. He doesn't start out by getting to the meat of the matter. He starts out by saying, I don't really know if I should be talking to you. I don't really have anything to say to you. So that also shows that there's not a waiver, not just that they don't ask the specific question. I think they know what answer they would have gotten based on what the other things he was saying. If they simply said, do you want to talk to us knowing these rights? We know the answer would be no.
of this language being unequivocal. And there's a lot of cases that talk about language that's equivocal and a language that's unequivocal. And it seems to me it's really hard to kind of pin down what language is equivocal and what language is unequivocal. And what's complicating that is the personalities from person to person. Some people are very direct in how they communicate. Others are nice and kind of don't want to get in your face and they want to politely say, I don't want to talk to you, or I don't think I should be talking about this. How do we draw this line?
I think the answer is the old answer that we usually hear in cases, case by case, totality of the circumstances. And so I'm not asking for the court to make a very sweeping Miranda ruling here that could end up in Washington someday. But we have here 4 times, and we've listed 4 main ones, but there's another time where he uses the F word. I mean, that's pretty emphatic. But he says, I don't got nothing to say to y'all. Another time, when asked if he would like to give his side of the story, quote, he answered, no, sir. When detectives continued to try to elicit incriminating response, he says, at this point, I'm not a lawyer and I don't know what to say, the right, wrong, or indifference. So I have nothing to say, sir. And 4, later in the interrogation, said, I'm done talking, dude. What we then do is we list 4 cases that have almost identical remarks by defendants, where this court and other appellate courts in the state have upheld that the one statement being made was an unequivocal revocation. In this case, you have 4 that each qualify as almost identical to where 1 was only required in those other cases.
But you also know that your opposing counsel has cited her cases that
Sure
with
has. She's
similar
done a
or
great
almost
job.
identical language where they come the other way, totally go the other direction, say that, you know, that wasn't enough and it was qualified.
It is, and she's done a great job, and I'm in doing so. It was an excellent brief, and there are cases on the other side, but it's in the totality of the circumstances. The only time he starts to talk about the facts is after he repeatedly makes these statements, and then they keep telling him, "Well, we only have her side. We're going to have to make up our decision based on her side," and that's not fair. And their answers as to why they kept asking him questions after he said these remarks was, well, we wanted to make sure he understood his rights, almost turning Miranda on its head, like, well, we'll continue to question you to make sure that you understand your rights. And I don't know how someone could demonstrate they understand their rights other than being, since he's not a lawyer, other than saying, I don't have anything to say to you. I'm done talking, dude. And another time is in, he uses language I can't repeat. But so they continue to insistently interrogate this man. And why we're arguing that it's not harmless error is this case, all of the evidence besides his statement, the gasoline on the ground, and the other physical evidence, which is, you know, can go both ways in this case, is the 911 call. So him saying, I didn't dump gas on the ground, which his own counsel is forced to go up in closing and say he obviously did, but he didn't want to admit to it, but he's still not guilty. So he's hoisted on his own petard by this statement being entered and ridiculed by the state for his denial, which does not fit with the evidence of the gas on the ground. And furthermore, it's him corroborating the victim that he did tow, albeit for a short distance, the trailer. And then he even makes the comment, which is almost conclusory, well, I didn't want to get convicted of kidnapping, so I stopped towing. So the statement's extremely damaging and was relied on heavily by the state in this case. And so does constitute reversible
Yeah, but he's not
error.
an expert on the law. He's just making a comment as a layperson.
No, but a comment I wouldn't have loved if I was his counsel listening to
Yeah.
it in court when that's one of the counts of the information.
Yeah.
If it's all right, I will move on to the next issue. In the next issue, we have the issue of the state calling a witness, a detective, and asking him if a cell phone found on the scene, if he tried to get into it to find the information from the cell phone, and his answer is he couldn't do so. This issue was raised by defense counsel in an abundance of caution prior to the testimony. So there was no invited error here. Defense counsel said, we're worried they're gonna try to do this just to give an implication that there's a consciousness of guilt, when there was no proof that the cell phone belonged to the appellant or that he had a code to it. This forced defense counsel, when the court ruled against him improperly, because it wasn't relevant, there was no link between that and the case. It was a red herring that was raised in order to make him look bad, and it forced defense counsel to actually question the officer about the fact that the appellant had provided a passcode for his phone, but it didn't match that phone. Now they coupled this, which the two issues again are almost conflated, in issue 3. And we cite a couple of cases where the court talks about the Florida Supreme Court and this court talk about what we refer to in the brief as a straw man argument or straw man evidence. In the Nowitzki case from the Supreme Court in 1990, the state in that case called a neurosurgeon to rebut the witness that the defendant was insane by saying he had no brain damage, but the defense had never alleged he had brain damage. So they created an issue where there was none. You know, in this case, they created an issue. Possibly the appellant was blocking officers from getting into a cell phone without ever establishing the connection between the cell phone and the defendant, other than it was found at that location. In Maldonado, which is this court's case from 2001, is a civil case. The court held that the fact that the plaintiff was an illegal alien was used to confuse, mislead, and prejudice the jury against him, which is what was done here. And Mr. Hollander, trial counsel, ably anticipated this and objected and asked the court to bar the state from doing it. And the state really had no cogent explanation as to why they were doing it. And then you couple that with issue 3, where then over a defense objection and a motion for mistrial, the defense says, well, we don't want the detective who spoke with the non-testifying victim to be able to say what he saw on her phone in terms of threats, because it's hearsay unless it can be established that those texts were sent by the appellant. The trial court says, no, I'm going to allow him to do it because they talked about threats on the 911 call, which doesn't seem to be a legal reason for their ruling, but that's what the trial court said.
Mr. Brown,
then,
just to let you know, you got to the 15-minute point, but I'm going to let you have a couple more minutes before we start eating into your rebuttal. I know you have a couple more points you want to make, and Ms. Klein will have an equal additional amount of time, so you may proceed.
Very good, sir. I'll try
to. Too many questions. I apologize.
No,
not at all.
I'll try to pick up the pace. So, you know, the issue then is, are these even his texts? And if they can't be established that they're a party admission, then of course they're hearsay. So there's no foundation because she's not there to testify. Then the court specifically said to the prosecutor, but don't ask about anything that she said about who sent her the text. The prosecutor proceeds to ask, and based on your review of her phone, did those messages appear to have come from Joshua Tanner? The answer was, from what she explained to me, it was from Joshua Tanner. So that she immediately violates the ruling of the trial court, knowing that she's going to elicit that response. Then couple it with the fact, the error of the court in even talking about them not letting him in a cell phone. Now the jury has the impression he's trying to hide nasty, incriminating, threatening texts, which demonstrate his consciousness of guilt. On issue 4, and again, I'll try to move it along. This is a fairly complex argument, but I'll defer to our brief on it. But the argument is that JOA should have been granted in regards to kidnapping. The 3-part test established by the court for kidnapping when it's coupled with another offense, and I'm getting frazzled with my notes. Is that if it's occasion or coupled with another offense, it must not just be a slight, inconsequential, and merely incidental to the other crime. B, it must not be of the kind inherent in the nature of the other crime. And C, must have some significance independent of the other crime. What we have here is amazingly a reverse kidnapping. He's there saying, please get out and leave my trailer, please go away, and she won't do it. And so the state even argues in its closing, you should convict him of kidnapping because they can't use secretly confine or the other theories. They have to use force. That's the only theory they can present. You should convict him of kidnapping because he tries to set fire to get her, and that fear keeps her in the trailer. Well, if that were the case, then it would be the burning, her staying in the trailer when he's actually wanting her out of the trailer under the state's theory would be a slight inconsequential, and it would be incidental to the attempt to set a fire. And it would be inherent in the nature of the other crime of trying to set a fire that it would put someone in fear. And lastly, the issue 5, the appellant respectfully requested and should have been granted an instruction on abandonment. It clearly was a fair argument. And the jury, the one jury question was these 2 sort of burnt sticks that were found, which one was closer to the trailer, because one had diesel on it, one had gas. There's testimony the appellant poured gas on the ground. There's testimony that he may have been trying to start a fire, but there never was a fire. There's testimony he knew how to start a fire. Defense counsel was arguing he had 45 minutes to maybe longer to set that fire, but didn't do so, that he should be entitled to argue to the jury that simply he changed his mind. He may have dumped gas on the ground, but then said, this is crazy. I'm not going to try to burn somebody up, and this could kill somebody. He changed his mind. The trial court clearly erred in not giving him the chance to make the argument. This was clearly on the jury's mind. So it's not harmless error. And I know I've gone way over. I'll appreciate any time I'm given at the end. Thank you for hearing me out.
You're welcome. You'll have the 5 minutes for rebuttal. Ms. Klein, you'll have about 3 or so extra minutes if you need it.
May it please the court. This is Catherine Klein, the Attorney General's Office, State of Florida. I guess we just start out with issue 1. we were talking, our opposing counsel was talking about saying Miranda was not waived in this case. And as it was discussed, an implicit waiver is sufficient under Burgess v. Tompkins, United States Supreme Court case. And what happened in this case is the appellant read his Miranda rights, and Miranda only requires the 4 warnings that he has the right to remain silent, that anything he says can be used against him in a court of law, that he has the right to the presence of an attorney, and that he cannot afford attorney. One will be appointed for him prior to any questioning if he so desires. So he was advised of these Miranda rights. He acknowledged he understood the rights. And they also advised him regarding perjury, and then he swore to provide a truthful statement. So then the first statement that he makes that is at issue.
Well, the
says,
first statement that he makes with regard to this issue is an answer to the very first question after the little pleasantries that were exchanged about the weather and stuff like that. Isn't that fair to say? The very first question, he says, what do you say exactly? He says, I don't got nothing to say to y'all, right?
Yeah, he says that. There's an exchange right before that where they ask him if he can explain why he's out there today. And he says, no, you could not. No, not at all. No, sir. Okay. You're covered water and sandy. You didn't stick around when law enforcement arrived to this address. Why is that? Because I'm wet. So he's giving some kind of, certainly odd responses to the question that he's just been giving. Yes, sir, that's why, and why, well, you're wet. And then this is all, if you listen to the recording, which I've done a number of times, some of this is, they're talking on top of each other a little bit. But yeah, I got nothing to say to you all. I don't know what's going on. I am effing freezing.
You know what might help me, Ms. Klein, if you could explain to me what is an unequivocal statement. I'm not talking to you, because you got 4 pretty strong statements by this guy throughout the course, and everybody just keeps coming. And we all know the reality of it is a guy like him is taken into custody. He's got cops with guns, badges, uniforms, cruisers. He's fully intimidated. He realized the deck is totally stacked against him. Any human would know that. And these people keep asking him questions, even though he has said 4 different times, I ain't talking to you. There's just something not right about this. So, so explain to me what he should have done to make it clear. And again, you're going to work from the assumption he's got the personality of a lawyer, which he doesn't. Okay, so help me with this.
Well, yes, he doesn't have the personality of a lawyer, although he does, in between his statements, make a case for, a bit of a character assassination of the victim. But what distinguishes him from cases where they've found an unequivocal right is that if you listen to the tenor, the context of this tone, the tone of the recordings, and in this case, the court can do this. I think it's a little bit different if you're listening to his live statements rather than just the plain record. But he had just waived his Miranda rights. And then they had a little conversation, and he says he doesn't want to talk. So,
well, back up just a second, because that preliminary point, he had just waived his Miranda rights. Your Mr. Brown on the other side says he did no such thing. So help me out. Where do you pull that notion from?
I find in the context of him being read his Miranda rights, acknowledging his Miranda rights, and then swearing to give a truthful statement. Yeah. That in that context, that's an implicit waiver of his Miranda rights.
I think you added to the list that we should listen to the inflections of his voice, maybe the way in which which I will tell you is a little bit troubling given the state of the law that Judge Morris has already indicated. I don't disagree with him that State of the
Like,
law
I
on this
know
as
in
to
the
what is
case-
equivocal, what isn't, is a little tricky to define. You want us to kind of put all this together and it looks like maybe put a new rub on it.
No, I don't think so. I think in the case, I'm trying to think, the one, Bailey, I think out of the first district, they discuss, again, that case, considering the context and the recordings and the tenor and the circumstances and how fact specific these cases are. And it's hard to make any kind of general statement of what would we have to say to invoke his rights, because they are all different personalities. And
I don't
different
I don't
situations.
disagree with that notion. The problem is let's say we were to write an affirming opinion here. All right, so you know what, you're right. At the end of the day, though, trial judges have to have some kind of guidance as to where to fall on these, and just telling them, well, it's case by case, listen to the recording, and maybe we'll affirm you, maybe we won't, isn't really much of a useful benchmark. I mean, it may be an accurate assessment, may or may not be an accurate assessment where the law is, but it assuredly gives no guidance to trial judges who have to call these as balls or strikes.
Well, I agree, and the trial court has a difficult job in doing so. And there are cases, if you just read the bold statements in those cases, they fall on either side of equivocal and unequivocal. And I think, again, this has to be it's very fact intensive, specific to.
So our review here is de novo, right?
Yes.
So we can
And-
elect as a panel to look at this fresh and fall on either side of that fence we choose to fall on. Is that correct?
Correct, because you have the benefit of having that recording. I mean, you certainly can listen to that recording on your own. There was some other testimony at the hearing from the officers who were in the car with the defendant when he made the statement. But you are in the position, in some cases we don't have a recording. We just have, an officer's statement.
Ms.
Here we
Klein,
do.
one of the things that was brought up earlier is the change in the questions that many officers will ask as part of Miranda. And when you struck a nerve, obviously, with Judge Lucas and with me, when you said that he then waived his right to remain silent. The difficulty is if the extra question were asked, now having heard your rights, do you agree to speak with us? And he said yes, then that would be a pretty clear sign of waiver. But here, what the officer says is, okay, you're now sworn in, I'm placing you under oath and so forth. Could you explain? And he says no. Now, if the officer would have said, would you explain? And he answered nope, would that be a more clear invocation? Is the word could versus would going to make a difference?
I don't, under this circumstances, I don't think that the defendant there is parsing coulds and woulds. I think that they're just saying, they're asking him, basically why we're out here today, and why did we, what's going on? Why do we have you in the back of this car, that type of thing. Could you tell what's going on? I don't know whether replacing a could or would.
Well, do we interpret it that he can't explain why law enforcement is there, or can we interpret it that, could you explain to me anything? And I know that's not what the question is, but that could be how he's interpreting it, is I'm not explaining anything. And I shared the concern when you have these repeated statements throughout the transcript, which arguably are not clear invocations, but they're also arguably clear invocations. And I am troubled by the fact that, I understand that last question, having heard these warnings, will you speak to us, may not be required under the state of the law, but it sure makes it clearer what the defendant thinks he or she is doing.
I agree. It would make it clearer, but as I said, it is not required under Miranda or, under Burgess, the United States Supreme Court case. And these statements, it's certainly that the state maintains that in context and under these specific circumstances of this case, the trial court did not err in denying the motion to suppress, and that he did not make an unequivocal invocation of his right to remain silent. However, if this court were to find otherwise, the state maintains that this error, under the circumstances, again, the specific circumstances of this case, it would be harmless. And it's not a reasonable possibility that the error affected the verdict. In this case, we had very strong evidence in the form of a 911 call from the victim, establishing and reporting the events as they occurred to her, the kidnapping and the attempted arson as they were occurring. We have testimony and physical evidence establishing the camper had recently been moved by the defendant's truck from its original location, and the camper was in the middle of the road where it would not normally be. Gasoline surrounded the perimeter of the camper, and burned sticks were found within a few feet of the camper. Threatening messages were observed on the victim's phone. Gasoline, and she also testified or reported during her call to those messages. Gasoline was found on the scene in the defendant's truck. Gasoline was on his pants, his socks.
The problem, unfortunately,
shoes.
with her phone call is she makes a lot of statements that are later proved to be not true. There were no gunshots fired. There was no fire set.
I don't know that that was.
And those are
not
very
true.
serious statements that she's making in a 45-minute long alleged excited utterance. Okay. At some point, a 45-minute phone call is no longer an excited utterance, but nobody made any effort to draw that line there. So, you know, I mean, you just don't get a 45-minute excited utterance. I mean, it just doesn't happen. Excited utterance is like a minute, 2 minutes, you know.
The admission of that 911 call is not an issue on appeal, and I would submit that everyone said she was still hysterical and excited at the time when the police finally got her to come out of that trailer. All the requisites for excited utterance were still there.
Yeah,
So,
no, you're right. It's not an issue here, but it's one of
not an
the,
issue.
again, the troubling things in this whole case. It's just part of the totally troubling picture. But here's what I don't want you to run out of time, and I'm afraid you are. So I want to focus you on Faison versus State, Florida Supreme Court decision, 1983. I'm interested in whether or not we have a kidnapping here or not, because we have these three elements. In order for a kidnapping, when it's done to facilitate another crime, as it was in this case, the alleged arson, there must be three things that happen. The kidnapping issue must not be slight, inconsequential, and merely incidental to the other crime. Well, certainly her being in that camper without permission, refusing to come out, and the camper being moved a total of about 20 feet, certainly falls in the category of slight, inconsequential, and merely incidental to the other crime. The second one is must not be of a kind inherent in the nature of the other crime. And once again, the whole issue was that the alleged arson or the attempted arson was supposed to be, she was endeavoring to be burned inside that camper. So it certainly would seem to be, it's inherent in the nature of the other crime. And three, must have some significant independence of the other crime. Well, you can't separate these two. They're all part and parcel. So under Faison, why isn't Faison versus State controlling and determining there was no kidnapping here?
Well, first of all, as argued in our brief, the state submits that Faison, this argument was not preserved first and does not apply in this case because the appellant was charged under paragraph 3 of that kidnapping statute 1A. The term kidnapping means forcibly, secretly, or by threat, confining, abducting, or imprisoning another person against her will and without lawful authority with intent to inflict bodily harm upon or terrorize the victim or another person. She was not charged under 2 on the second paragraph there to commit or facilitate the commission of any felony. And under Briggs, the Faison test only applies to the subparagraph 2, and that's Briggs v. State 745 Southern 2nd, 1051. So we would say, since she was not charged under 1A2, we don't have to consider that test about it being merely incidental to another crime. And here there were two separate crimes, the kidnapping and the attempted arson. And one was not necessarily just incidental to committing the other. What happened here is we have a kidnapping when he hooked that trailer up after and started towing her, and she was afraid to come out because he had pounded on the door, and as she said, she was on 911 and he had threatened earlier. So that's the kidnapping, the moving of her from one location to another. He has second thoughts and drops her, but then that is when he comes and gets the gasoline, presumably either from his truck or somewhere else on the property, and then surrounds the vehicle with gasoline and attempts to light the gasoline. That's the attempted arson. The towing is the kidnapping, and Faison does not apply.
But all that actually to me sounds like an effort to get her out of the trailer. But ultimately that would be a jury question, wouldn't it?
Yes,
what
it
was
would.
the reason to move it, and what was the reason for attempting to light a fire? But it does sound at least arguably consistent with his theory that I just wanted her out of there.
And I think that is his main motivation. And she's terrified to come out here because she's being terrorized. So the fact that she was in there initially voluntarily does not matter. Now she's being confined by threat of infliction of a bodily harm or the terrorizing of her.
Well, she was in there voluntarily, but also trespassing. She was in there without permission and had been specifically
Well, that's
told
according
not
to him.
go there. So
according to him, she doesn't have permission, but it sounds to, if you read the transcripts of the trial and listen to that call, there's another person who actually is the lessor of this property, named Mark Green, and he may have given her permission to be there. We don't know. The defendant came back and thought she shouldn't be there, and he was determined that she shouldn't be there. So I don't know if you can really say that she was trespassing.
well, the testimony that I read is that the owner of the property, I think of Mr. Green is his name, which had told her, you are not to be here unless you're with him, Tanner.
Mm-hmm.
You're not to be here. And she clearly, obviously was there without Tanner. Tanner showed up to remove her. So,
I guess if you're trespassing, it doesn't give a permission to kidnap and terrorize someone.
Counsel, could you just really briefly touch upon the second issue, the relevancy of Detective Wedgwood and the Samsung phone that he couldn't open? Usually we think of relevancy in criminal trials as revolving around the elements of the offense and affirmative defenses, and just tell me what does this have to do with anything, and why did it get in?
What happened in this case is the phone that they're talking about, it was recovered from the underneath the driver's seat of the appellant's vehicle.
Right, and he testified he couldn't open it. Right. So what does that have to do with it? What does that have to do with what the criminal culpability that the state was trying to prove here?
Well, they found it under the seat, and they did a motion to compel to get the password. They got a password that didn't work. The relevancy here is it's to counter an argument that the law enforcement has not done their job in investigating.
Yeah, and the case law tells us, that's what I thought. The case law tells us, though, the steps of investigation just ordinarily are not relevant. I think I remember reading one case that likened it to venial sin, that the stuff just keeps getting in, but it really shouldn't be. And I found it a little bit troubling that it really didn't seem to have anything to do with anything other than to just put that issue in play for purposes of closing statements, purpose of potential impeachment. I mean, the way you deal with that if you're a prosecutor is, look, if the defense puts the steps of the investigation at issue and says, hey, you didn't cross all your T's and dot all your I's, you recall the witness and say, well, did you cross your I's? Because now it's at issue. Now they put it in there. But here, you all did that as a kind of a preliminary strike, and I'm just not sure how or why that is relevant in that context.
Well, and also here, they did put it, the state maintains that it's relevant that, I mean, this phone was found and that it was in his car and he had access to it. And it relates to the fact that he had the ability to send threatening text messages, whether or not they were ever recovered. And the state was not the party that introduced the evidence that an incorrect password had been provided. They just submitted that they couldn't get into it because it was locked. It was on cross-examination that defense counsel brings out the fact that they got an incorrect password. And you could take that either way, like, oh, that's not my phone, or I guess you could also take it, they gave me an incorrect password. And the state would submit that even if this was error in this case, it would have been a harmless error. And it certainly wasn't one that was, because this was also on a motion for mistrial. It wasn't such an error that would vitiate the entire trial. And does the court have any questions on any of the other issues?
No, thank you, Ms. Klein.
Yep. The state would submit that this court should affirm the trial court did not err in denying the motion to suppress, and none of the other issues are reversible. Thank you.
Thank you, Mr. Brown.
Thank you, please, the court, Ms. Klein. I'll just address these in reverse order in a true rebuttal fashion, just the issues the court raised with Ms. Klein. Regarding the cell phone, Your Honor brought up the issue of, is that countering an argument that may be made, like an anticipatory rehabilitation, if I'm using the correct term, and defense counsel brought it up with the judge at sidebar, specifically to say, I'm worried they're going to do this. I do agree with the state that if he had then got up and asked the case agent, well, did you try to find out where those texts were from? Did you examine all the evidence at the scene to determine if you could find out? Then he certainly would have opened the door to the guy saying, well, yeah, actually, I tried to open the phone. We actually obtained a password from your client. It didn't match that phone, and I wasn't able ever to get in it. But the defense would, then that would be on the defense counsel. But the defense counsel specifically said, we don't want to raise it. And respectfully, the state argues, well, it's harmless error in the grand scheme of things, but it's coupled with the hearsay testimony, specifically against the court's order, that the victim said, these texts on my phone came from Mr. Tanner. And therefore, the jury has the inference now, Mr. Tanner's trying to hide that evidence, coupled with Mr. Tanner's statement, where now the state's saying, well, he's hiding evidence, he's hiding threatening texts, he's lying about gas. His own attorney has to admit that because it's on his clothes from the statement that comes into evidence. I do agree with the court that the victim in this case was not allowed to be on that property. She was not allowed to be in that trailer. Now, I agree with counsel that is not necessarily a defense to a kidnapping, but it certainly explains and bolsters what Mr. Tanner says in his statement, which we already should never have been admitted, which is, I was never trying to confine her. I just wanted her to leave. Now, the court has pointed out, why is it not harmless error? And I think the court's made my argument for me, why it's not harmless error to include this statement, which surely should not have seen the light of day in this courtroom. Because, as the court has pointed out, some of the things the victim says in this lengthy phone call and the objection to the length of it was not preserved properly, although the latter half of the phone call is mostly her talking about, can she get a ride to Fort Myers and things of that nature that really aren't harmful to my client. But she says several things which are demonstrably false, as proven by the state's own evidence technicians. She says she sees flames outside the trailer. However, all they found was a couple of old sticks with a little bit of charring on them. They didn't find a burned area. They found gas that had not been lit, soaking the ground around the trailer. She says she hears gunshots, but no shell casings are found. There's no GSR or any other evidence that there were guns fired. And 911 operator does not hear a gun being fired over the phone when speaking with her. And she says it's happening right outside the trailer. So there's plenty of things she says which are demonstrably false, that without his statement, that would be the state's entire case. Now, going back to Faison, I agree with counsel that Faison specifically addresses a separate subsection of false imprisonment and kidnapping, but the way the state argued it is exactly what Faison is talking about. The state didn't argue simply hitching up and towing a few feet. is sufficient to get a kidnapping conviction. The state argued when he's trying to set that fire, he's terrorizing her, making her too afraid to leave, thereby confining her. And that because he's guilty of arson, he's also guilty of false imprisonment. That's almost word for word, well, it's a paraphrase of what the state said in its closing argument. So that's the reason the state's arguing that way. And that's because there are cases, including, pardon me for losing my spot. There's a case called Rancor, which this court decided in 2000, 766 Southern 2nd, 1071. That was an unfortunate case involving the rape by two men of a young lady. The court in that case held that when she got a ride with them, that was not a false imprisonment to begin with, because she accepted the ride voluntarily. But as the victim in this case voluntarily entered the trailer, actually voluntarily against the orders of the owner. But it became a false imprisonment for two reasons. One, because when they passed her stop and she said, "That's my stop," and became concerned, they refused to pull over and let her out. And that two, they used physical force to remove her from the vehicle. When they then raped her, they said that's what converted her voluntary presence in the vehicle into a kidnapping. And that's why the state argued in this case that way, where the state said, and it was preserved, there was a JOA argument made by Mr. Hollander, where the state said, well, it wasn't just the moving of the trailer a few feet, which is obviously de minimis, and he changed his mind, but it was the fact that she's terrorized because he's supposedly trying to burn her alive, or at least terrorize her enough to get out by setting a ring of fire around the trailer. And that's why Faison does apply here, because that's how the state argued the case. That's how they chose to argue the case. Lastly, I would just add, again, on the abandonment instruction, the evidence shows that there's a very lengthy period of time. Not only was this call like 45 minutes, it took the police quite a bit of time to locate my client after that. And during that time period, there's testimony by the owner of the property who was brought up that the two were trying to operate a gator farm together, and they were clearing this rural property in Charlotte County, that my client on numerous occasions had burned brush and was very capable in doing so, and knew how to set a brush fire properly, to dispose of brush, so that therefore he has this circle of gas around the trailer. He has a lighter and he's able to set a fire. And there's no evidence whether those sticks were from an old brush fire or whether they were from an attempt to ignite that gas. But I would suggest common sense would tell you if he was igniting that gas with his capabilities and there being a large pool of it going around the trailer, it wouldn't have stopped there. It would have burned its way clear around the trailer. So he was at least entitled to the instruction.
Mr. Brown, you can take about 10 seconds and wrap up your past your time.
I only needed 10 more, so it's perfect time. He was entitled to at least have the jury hear the law, that if he had chosen to abandon that crime rather than being stopped by some other force, it was not an attempt. Thank you all for hearing me out today, and again for your indulgence this morning.
Very good. Thank you both. That concludes this oral argument session. We are adjourned.